Everybody? Okay, Robert?
All right. Thank you. Yeah, I'm set. Thank you, everybody, and good afternoon. I think I know most of you, and you know me, but for those of you who don't, I'm Robert Eglett, the senior partner here at Eglett Adams. With me is a senior partner at the Demopoulos law firm, we have jointly teamed up to do these cases, as well as some of his lawyers are with him as well as some of my partners. Half the firm, I think, is up in northern Nevada arguing one of the opioids motions today. So, last Thursday, the Eglett Law Group and the Demopoulos Law Firm filed a landmark lawsuit on behalf of this young woman right here, Tina, and on behalf of her husband, Albert, who claims to have developed multi-brain tumors directly linked to the use of a widely prescribed birth control injection called Depo-Provera. And the lawsuit takes on Pfizer and several generic pharmaceutical manufacturers, including Viatris, Greenstone, Prasco, Pharmacia, and Upjohn Company. The complaint alleges that the defendants failed to adequately warn patients that Depo-Provera would increase their risk by 555% of developing a type of brain tumor called intracranial meningioma. Intracranial meningioma is a medical condition in which a tumor forms in the membranes surrounding the brain and spinal cord and causes a number of severe and debilitating symptoms ranging from vision problems and difficulty speaking to seizures and even death. The complaint alleges that the defendants have been aware of these risks for decades, but failed to share the information with patients, prescribing doctors, and medical professionals. Depo-Provera, which is marketed as Depo-Shot, was approved by the FDA for use as a contraceptive in 1992, but has been used for contraception in international markets since 1969. Depo-Provera is administered as an intramuscular injection every 3 months and by a physician normally, and contains a high dose of progestin, which is a synthetic progesterone-like hormone that suppresses ovulation. Each of defendants' names named in the lawsuit manufactures, distributors, markets, sells, and profits from brand name or generic Depo-Provera in Nevada and throughout the United States. During the time that defendants have marketed and sold Depo-Provera, they have failed to adequately test Depo-Provera to investigate the potential intracranial meningioma. And defendants have also failed to provide adequate warning to patients and the medical community of the risks associated with using this drug. The complaint alleges that the defendants knew or should have known that Depo-Provera, when prescribed and administered as intended, can cause or substantially contribute to the development of meningiomas based on the decades of scientific literature documenting this relationship. Since at least 1989, several studies have established that progesterone and its synthetic analog progestin, Depo-Provera in particular, can cause or substantially contribute to the development of meningioma brain tumors. Further, in March 2024, the French National Agency for Medicine and Health Product Safety published a large case control study in the British Medical Journal, one of the premier scientific journals in the world. The authors found that the use of Depo-Provera resulted in a 555% increased risk of developing intracranial meningioma. Now, look, I've been suing pharmaceutical companies for 25 years now. And I can tell you, I have never seen any pharmaceutical product that increased the risk of any problem, much less brain tumors, anywhere near as high as 555%. And the studies have been around for years, and yet these pharmaceutical companies never warned the American people or the prescribing physicians of this risk. The study also examined the effect of several other progesterone-based medications and found that Depo-Provera had the highest risk of meningioma surgeries among the contraceptive products studied, making it significantly more dangerous than other contraceptive drugs and treatment options for women. The defendants willfully failed to warn, instruct, advise, educate, or otherwise inform patients and their prescribers about the risks of meningioma or the need for monitoring for symptoms of the same. According to the Drugs at FDA website, the U.S. label for Depo-Provera has been updated at least 13 different times since 2003 and was most recently updated in July of 2024. And why this is so important here is, despite the fact that there are at least 14 iterations of the Depo-Provera label, defendants' labels have never, ever contained any warning or information whatsoever on the increased risk of developing severe and debilitating intracranial meningioma from Depo-Provera use. The U.S. label for Depo-Provera still, to this day, contains no warning about the risk of developing meningioma to this day, even though the British Medical Journal study was published in March of this year, 4 months before the most recent label update. This is nothing short of criminal conduct on the part of these pharmaceutical companies. The defendants were clearly on notice of the substantially increased risk of developing meningioma from the use of their drug when they updated the Depo-Provera label in July 2024, and yet they still included no information whatsoever about the meningioma in the label, thereby endangering tens of thousands of women in the United States. Moreover, defendant Pfizer has changed its European Union and UK and Canadian labels, which now include meningioma as a risk, and advise patients to speak to their doctor before using Depo-Provera if they have any history of meningioma that has not changed or attempted to change the U.S. label. Not even made an attempt. The complaint alleges that defendants' failure to investigate and warn of the risk of developing intracranial meningioma from Depo-Provera has caused Tina Stevens Smith, as well as tens of thousands of other women across the United States, to suffer substantial damages. Tina Stevens Smith was administered approximately 80 shots of Depo-Provera over a span of 20 years pursuant to her physician's prescriptions and her reliance on the Depo-Provera shot to be appropriate and safe. Thereafter, she developed concerning symptoms such as severe headaches, blurred vision, speech impediments, and trouble communicating and maintaining a normal conversation. She was diagnosed with 3 densely calcified intracranial meningiomas, including behind her right ear and the base of her skull, which is a particularly dangerous place for these tumors and incredibly difficult and dangerous surgery with a high probability of death. After a dangerous surgery and 30 radiation treatments, she continues to suffer from painful and debilitating symptoms. Through their affirmative misrepresentations and omissions, defendants actively concealed the significant risks associated with Depo-Provera use from Tina Stevens Smith and her physicians, as well as from tens of thousands of American women. Because of defendants' actions, Tina Smith, her physicians, and tens of thousands of other women across the United States were unaware that they would be exposed to the risk of Depo-Provera use and would be permanently and severely injured as a direct result of taking this drug. The complaint seeks damages for physical and mental pain and suffering, past and future medical expenses, and loss of earnings and earning capacity, as well as punitive damages against the defendant for their outrageous behavior here. The Egglet Law Group and the Demopolis Law Firm are now accepting cases from women in Nevada and across the country who received Depo-Provera or the generic version and then developed brain and or spinal cord tumors or lesions called meningiomas. We have already jointly started marketing for these and expect to have 1,000 cases signed up by May of next year. If you or someone you know developed meningioma after receiving Depo-Provera injections, please visit the Egglet Law Group or the Demopolis Law Firm's websites to read the complaint and submit a claim. With that, we will open it up to questions at this time that Mr. Demopolis and I are certainly willing to add. And I want to add that this is not the first case that Steve and mine's two firms have worked on together. We've had a long friendship and relationship and have been very successful in bringing cases as a joint firm. And we talked and decided that the best thing for us to do for our clients is to work on these cases together. Between our firms, two firms, we have nearly 35 lawyers at our disposal. Plus, there are other friends of ours around the country, other law firms who are doing these cases as well, including the first case that was filed last month by Weitz Luxembourg in California. So we'll be working closely with all these firms to prosecute these cases. Again, any questions anyone has?
Are you looking at a potential class action lawsuit?
No, this will be what's called a multi-district litigation, an MDL. Once there's about 8 or 10 cases filed in different states, federal courts around the country, the plaintiffs working together, I've mentioned one of the other firms, there's several other firms around